something. My sense of the judgment is that, but for the influence, right, certain approvals would not have been obtained. That's my sense of the judgment. And I say this, and it's very important, it's captured on record, that what is at stake is not merely a discussion of compromises or bribery, but an actual bribery that has led to the conviction of Mr. Baffuor in the United States of America. And the persons he's been convicted for bribing are not private persons in Ghana. They are public office holders who were in a position to make one decision or the other in respect of the AXA energy deal. And so basically, they are people that have compromised public decision making at a very point where Ghanaians were very vulnerable. And when you listen to Ben Boakye, he captures it very well. He captures it very well to the extent that clearly the systems that we have put in place, indeed not Ben Boakye alone, Dafeamekpor also makes that admission. Dafeamekpor also makes that admission that the systems, right, failed to the extent that he even makes reference to Parliament. And so these are very important matters that we cannot gloss over. We cannot gloss over them because, not merely because of the failings that I've highlighted. We cannot gloss over them because they are becoming one too many. One too many instances where Ghanaian, public contracts are said to have been compromised. And then the persons involved or at the heart of the compromise are convicted in foreign courts, right? It exposes, one, the failure in our systems domestically, the systems for ensuring value for money, and then the systems for ensuring that we prevent corruption or we prosecute corruption locally. And so these things, for me, make it very necessary that in any serious country, there will be an inquiry. And I'm happy my brother Dafeamekpor agrees with the New Patriotic Party's position that there's the need for an inquiry, right? And so what it means is that the call we made was not a frivolous call. The call for an inquiry is very, very necessary for any country that wants to make progress. When you have your systems for ensuring value for money, your systems for ensuring prevention of corruption, your system for ensuring or for prosecuting corruption at that level, right, failing not once, not twice, not thrice, but many times, it's then obvious that something is terribly wrong with your system. And so there is the need for an inquiry. And when we do the inquiry, we must make sure that we act on the inquiry. That said, let me proceed to make one correction, and I will address the issue of the Attorney General, our position on the Attorney General. Something, I want it to be on record that at no point has the New Patriotic Party ever, whilst in government, filed nolle prosequi in respect of any of our appointees, former appointees, persons who are exposed to us sympathetically or however you want to describe it, stand trial for corruption or corruption-related offense, and then nolle prosequi has been filed in relation to it. Under the New Patriotic administration, a former appointee under President Baffuor, Adjei Malamisa, was prosecuted, convicted, and sentenced to in prison. So we are not known for that as a party, very respectfully. And, these are very serious national matters, and I don't want us to bring in, I don't want us to make it too partisan. And so we have to proceed very cautiously. We don't have to make it very partisan, because when I listened to Ben Boakye, I cringed that a power plant that we spent over $700 million on could only work for 16 hours. It's for 16%, right? Could only work at 16% of the rate at which it's supposed to work. And we are spending over 700 million. That could only have happened because of the influence that was at play. And it happened because, look, and it happened at the time when Ghanaians were so vulnerable, such that they like somebody being drowned by water. He wanted to hold on. We wanted to hold on anything and anything that we could see. And so people are taking advantage of us in our vulnerability. Samson, the general concern that Ghanaians have had all these years has been that the Attorney General, be it under MPP, be it under NDC, is not able to prosecute its own. That was the principle that informed the introduction or the setting up of the Office of the Special Prosecutor. True or false? Hello? Something true or false? Hello?
We're listening to you. Go on.
Something, that was the principle that informed it. And so when we say that an Attorney General, we don't trust him to prosecute his own, first and foremost, it is based on this principle. However, this particular Attorney General has typified, has exemplified that principle. He's the first Attorney General in the history of this country to have, in one full swoop, by the stroke of a pen, filed nolle prosequi against members within its party, persons who are linked to his party, right? One full swoop. He did that. That was the major decision, his first major decision as Attorney General. Now, you are telling me that an Attorney General who has done this can proceed to prosecute his own. Look, the Attorney General didn't end it there. He even brought a gentleman who is famed to insult, right? The NDC didn't end it there. A gentleman who is famed to insult everybody in this country, disrespect chiefs, very respectable people. You've done a commentary, you've done an opinion on this, so I don't need to belabor it. Gave him security protection so that this person can now come and be laundered in our court, be cleaned in our courts. And you are saying that you have confidence in this Attorney General? Look, the persons involved, or the persons who potentially may be culpable in this matter, some of them are still appointed in this government. They are appointees of this government. You have Mr. Dr. Kwabena Donkor, for instance, who is a board chair. And I'm not saying he's culpable. I'm saying potentially he may be culpable. He's a board chair. He's a board chairman.
Wait, just hold on. Go on.
He's a board chairman in this government, right? One of them, who used to be the chief executive, Alhaji Amuna, who used to be the chief executive of Gridco, is now the board chair of Electricity Company of Ghana. And since the matter broke, right, since the conviction broke, in fact, my brother Roxanne alludes to the fact that this matter has been with us for some time. Nevertheless, notwithstanding the fact that this matter has been with us, prior to the conviction, these persons had been given appointment. In fact, the governor of the Bank of Ghana, and it's not news to us, because look, the governor of the Bank of Ghana was standing trial, right, for the banking sector cleanup. When his matter, in fact, his was exceptional. The nolle prosequas and the discontinuance that was done by the Attorney General, his was even exceptional. The Attorney General withdrew the charges against him. and then subsequently was appointed the governor of the Bank of Ghana. That tells you the extent to which this government will go to protect its own. Those that were yet to be appointed, who were standing trial, their charges were discontinued. Let's appreciate it from this perspective. The issue really is not the composition or constitution of legal vacation courts. That really and truly is not the issue, and we all know. It is an issue, or the issue really is that in the course of the legal vacation, a trial is supposed to be taking place. It has become an issue because it has never, ever been done unless the parties and the lawyers agree that they want to submit themselves or they want to subject themselves to that particular arrangement.
It has never been. It has never happened.
I'm saying it is not something that happens during the legal vacation.
How about emergency cases? I've done 2 emergency cases in the vacation, election matters, 2016 and 2024. I've done 2 emergency cases in the vacation courts.
Samson, you did an emergency case in the vacation courts because perhaps the constitutional instruments that regulate the resolution of election disputes made express provision for it. Or the parties and their lawyers agreed that they would do it during the vacation. Otherwise, it is not something that happens during the legal vacation. And as we speak, nobody has ever come to say that this is a normal happening during legal vacation, right? And so there are exceptions. But in the general course of things, it is something that doesn't happen. That point, very respectfully, is undisputable. And you agree with me on this.
So if it's not the standard, but it can be an exception, what is the problem?
Good. And so that is why you read Article 296 of the Constitution. You see, the Chief Justice is exercising an administrative power. And inherent in that administrative power is the exercise of discretionary power. In the exercise of discretionary power, there should be a basis for which certain exceptional situations happen so that people don't read meanings into them. Why is it that of all the criminal cases taking place in this country, and I can assure you that these are not the only cases involving public office holders, potentially there may be some who are not politicians, but really and truly, there may be other trials that are going or cases that are ongoing, which involve persons who had previously held public office or they are public officers and they are being tried in connection to something that they did whilst in office. And so the question is, why just these cases at this time? If you cannot explain, then it raises question about the proper exercise of the improper exercise of discretionary power. That we cannot dispute. And in fact, when Vicky raised it, look, that really is the point. That is where the whole point is. Why is it not that it is Republic versus Razak, which is being done today? Why is it that it's not Republic versus Kwaju, which is being done today? Why is it that it's not Republic versus whoever, which is being done today, right? And this is how democratic institutions are developed. If you don't do it like that, you build a system of vindictiveness. And so tomorrow, when somebody is also in office, he will want to pay back. But when we know that it's a proper exercise of discretionary power and that there is a basis for which these cases are being done and they are devoid of lack of candor or they are devoid of any witch hunting, then everybody understands that there is fair play. But in the circumstance of this case, when generally you are trying to do something which is not done during legal vacations, and then you are also proceeding to do it in respect of persons who are connected to a particular political party, then clearly you have a problem. For instance, if you look at Kojo Okonkrome's, I think that the case that has gone to the Supreme Court, the Supreme Court is being called upon to sit on an injunction on the 20th of this month. Have you had a situation where, with the exception of election dispute, the Supreme Court being empaneled during legal vacation? You've not had it. And so when these things happen...
So Ransford France will be an election dispute, right? Because Ransford France, they were called to sit in the vacation.
Ransford France?
Yes, it's about elections. Please go ahead.
Yes, it's about elections. So it's an election dispute. And that's why I'm saying that these things, when they happen in the manner which is an exceptional situation, and there is no basis, then of course people will be worried and they will say that...
You are suggesting that Kojo Opon, having filed his writ and issued an application for injunction, you would have expected the Supreme Court would have waited to deal with that matter in October when it resumes. Is that it?
Samson, the Supreme Court registry, when was the last time it gave a return date during legal vacation? When? And so, if the Supreme Court is being called upon to sit during legal vacation, when we have not seen anything of its kind, apart from elections petition, and there's no yardstick, there's no guideline for measuring these occurrences, would that lead you to any other conclusion other than selectiveness?
Are you unhappy because that potentially will dismantle the mischief? And the mischief is that you file an application for injunction, hoping that once that application is pending, the court's hands will be tied. They will not be able to continue with those cases until we resume in vacation. But should you also not be happy that they are recalled to come and sit on the matter, and they will sit on it quickly so you get to know the outcome?
I'm saying, ordinarily, I should. However, when it is an exceptional situation and it is being done in respect of a selected matter, right, then I become worried and ask myself, what kind of system are we building? Yesterday, most of us were not pleased that a matter will be filed in the morning at the Supreme Court on a Friday, and the Supreme Court will be empaneled on that Friday afternoon to sit. Most of us were not happy, right? Today, this is happening. If you continue like this, you make our democracy fragile.
But is that not the speed and efficiency we have been asking for?
Give us guidelines to ensure, for us to know that this kind of speed will be applied to all cases, not cases involving persons of the MPP. Give us that. Okay? Because if you may accommodate me, let me make this point. Samson, we need to look at this matter within a certain context. And we have to be very frank among ourselves. Okay? We have to look at it within the context of how in time past we have not been happy with how the judiciary has been so cozy with the executive. Today, when you are doing things, right, in a manner which ordinarily, until this happening, could not have been foreseen. Samson, did you ever foresee a situation where the Chief Justice will empanel outside.
Don't ask me questions. I'm asking you the questions. So not long ago, Dafeamekpor filed a similar case like that, and I'm talking about the injunction. I'm talking in a parlance that everybody else will understand. I want to try and strip my interventions of legalese. And you were happy that he filed the matter, and by afternoon, a panel was constituted and the case was being heard. The NDC was up in arms. That was too swift. So what is this?
Samson, what it really is that in the same token that we thought that what happened yesterday was an exceptional case, which didn't have any prior guideline to make it predictable. This same situation is also an exceptional situation. And when it continues like that, you don't have a situation of predictability. And you know that one of the cardinal principle upon which our law tribes, particularly those of us of the common law stock, is the principle of predictability. And that is why judges, for instance, are required, even though Article 296 creates an exception, there is supposed to be a guideline, either in case law or in the form of directive by the CJ. As we sit now, there's no such directive. So, that should be guiding us.
So last week I was asking the question, the decision to adjourn a case is strictly in the bosom of the judge that is presiding over the case. If there are about 11 or 12, or is it 13 judges who are vacation court judges in Accra, and they have their cases they are hearing, of course, they are also doing the cases of the other judges who are on break. And as we know, they don't do the substantive cases of the other judges who are on break. They only hear applications that are urgent and so on and so forth. Why not approach the judge and give a reason why the case should be adjourned? Why target the Chief Justice who issued a general warrant, not a warrant for oral cases?
So, my brother, first and foremost, we need to appreciate that the power of a judge to adjourn a case is discretionary. And being discretionary power, it is restricted not just by statute, it's also restricted by practice, right, as we've come to know it. And therefore, the practice as we've come to know it, right, is what I have already stated being the general position. I agree with you. One of the options is to approach the judge. But from every indication, and indeed, if you listen to the commentary that was published in the case of Dubois by Justice Achibonga, my good friend, one of the things that came out was that the judge has said that there's only there are only two bases or two things that can stop him from proceeding, right? The only basis for which he will stop proceeding is when the Chief Justice intervenes. And so from the judge's own showing, it is the Chief Justice that can stop him from proceeding.
You have seen the warrant. You have seen the warrant. Does he really need the Chief Justice's permission to give his adjournment? You have also heard the Chief Justice say what is obvious and what we all know. Adjournments are not for the Chief Justice. So he can actually adjourn the matter. He doesn't need the Chief Justice, correct?
Well, the judge who has the power to adjourn the matter is now telling you that he can only be stopped from proceeding by the Chief Justice. What does that also tell you?
After he says that, then the Chief Justice now says a judge doesn't need his intervention to adjourn any case, which is actually not something new the CJ is saying, which is not something the CJ should say, because that is what it is.
Okay.
He has absolutely no business in it.
That should tell you that we have a real problem on our hands. The judge that can stop proceeding with the matter is telling you that it's the Chief Justice. And the Chief Justice is also telling you that it is the judge. And so which is which? Who should we go to? As a popular musician said, Yenko ata anasi yenko abna. Who should we go to? Because the judge is telling you that he cannot stop it. It is the Chief Justice that can stop him. Now the Chief Justice is telling you that it is the judge. There is something in this that we have to interrogate. And I think that the judge is really pointing to something. The judge is pointing to the fact that in this matter, my hands are tied because I am under instructions to proceed. It is the Chief Justice alone who can stop me. This is what the judge is saying. And that raises a fundamental question as to the independence at that level. Because we all know that when it comes to the exercise of judicial function, a judge is not under the influence or compromise of anybody apart from himself.
And beyond that, Nana, you have seen, and beyond that, you have seen the warrant. The warrant doesn't say the judge, hold on, the warrant doesn't say the judge should hear only oral cases. So this is a judge who has a court and would have dockets that you have to attend to. So, having seen the warrant, do you think that the judge is right by saying that he needs the CJ to be able to adjourn any matter?
Thompson, that is why I am saying that there's more to what we are discussing. Because I knew Justice Achibonga in practice. He's a very solid judge who knows his law, and I have a lot of respect for him. Justice Achibonga knows his onions. And like you rightly pointed out, there's a warrant before him, which is of general description and prescription. And therefore, he's not constrained by the direction of anybody. Yet he tells you that the only person that can stop him is the Chief Justice. When he's telling you that the only person that can stop him is the Chief Justice, what does that tell you? What does that tell you? It tells you that he is constrained. And
do you sincerely think that this matter should be litigated in the manner we are beginning to see? Somebody has gone to the court to say that legal vacation is unconstitutional, and then another person goes and says the legal vacation warrants issued, should not entertain part-head cases. Do you think these are matters that should be litigated?
You know why it has become necessary for this matter to be litigated? It's because it has never happened before. And so everybody's taken aback. Everybody's taken aback.
All right.
That in and of itself should tell you that there's a problem.
All right.
There's a rotten onion in the room which we are dealing with.
Submission on this matter. Now let me invoke Jeremiah 17:9. Said the heart is deceitful and above all things desperately wicked. Look, this wicked propaganda against the CJ was done by the GBA, the Ghana Bar Association. And I'll demonstrate why. 4 lawyers, Senior Baffuor, Senior Godfrey Adjei, Senior Ay3ka, and Senior Samuel Kujato. 3 of them.
Is it Samuel Kujato or Bath?
Well, the bar mentioned their firms. Mm-hmm. So let me straighten that. So 3 law firms supposedly petitioned the Ghana Bar Association, citing facts that are mostly inaccurate as a basis of their petition. Senior Baffuor, he petitioned directly to the CJ, so 4 petitions in all. If you read Godfrey Adjei's petition in part, the reason why he says himself and his firm cannot be in court, he says they are going to mark exam scripts. You have taken a client's money and promise that your legal services will be available 24/7, 365 a year. Day and night, as your lawyer, I will serve you. That is why lawyers, we charge on hourly basis. Your client has been served with a hearing notice to appear in court. You are writing a petition to your bar association, and you are claiming that you have subscribed to mark exam scripts of the law school for which you are paid fees. When you mark exam scripts, you are paid fees. So you are saying that you are prioritizing one legal service over another. As a basis of that, you cannot appear in court. Can that be a basis for which a lawyer says he can't appear in court? Is it not something you negotiate with the judge? They didn't do that. Ay3ka says that he needs his vacation. He can't appear in court. And the hearing notice that have been served on him, he says that it amounts to selective justice. Why? Because his cases have been particularly given to the judge to hear in the vacation. And the GBA doesn't interrogate these facts. So based on them, then they send a petition to the CJ dated 10th August. And they are quoting verbatim these issues. Now, like you alluded to, my big sister, if you read the warrants issued to the judges, and let me read one warrant issued to Charity Asem. This is Charity Asem's warrant to sit during the 2026 legal vacation. By virtue of the powers conferred upon me, I hereby authorize you to sit as an additional High Court judge at the Specialized Court 2, Law Court Complex, Accra, during the 2026 legal vacation and conduct hearings. Charity Asem.
This is dated?
This is dated 23rd July 2026. Another 23rd July 2026 warrant to Justice Achibonga. It says so it's a look, the warrants are like a court form. What changes are the names of the judges, the dates, and maybe the author, because you may have a different CJ. Otherwise, they are like court forms. And I took some steps to dig around. From 2017 to 2026, let me show you the number of courts that sat in Greater Accra alone. In 2017, 2 high courts sat. Justice Mills Tete sat at General Jurisdiction Court 4, 2017. Justice Akabuafu sat in GJ Court 6. That's Accra alone. In 2018, we had 6 courts that sat. We had Justice Mele Wood.
You don't need to mention.
No. Yes. It's for the facts. Look.
I mean the numbers and the fact that they sit.
Okay.
Vacation there.
So in 2018, 6 courts. In 2019, when Godfrey Adami was then Deputy Attorney General, 11 courts sat. 11. Now in 2020, 12 courts sat. 2020, 12 high courts in Accra. In 2021, 11 high courts sat, and the judges' names are all there. In 2022, there were 12. In 2023, there were 13. In 2024, there were 12. In 2025, there were 13. In 2026, there are 12. So there's a certain consistency within the past 10 years as to even the number. Now, in respect of the data regarding vacation courts, at least I was able to procure the data for this year. In this year, apart from the Greater Accra courts, and if you take Tema and the adjoining high courts, we have about so many courts sitting. Now, if you take Ashanti region, where is Ashanti? Ashanti should be somewhere here. If you take Ashanti region, you have 9 high courts sitting. It's vacation courts. Western region, 7. Central region, 7. Eastern region, 7. Bron and Ahafu area, 5. Volta, 5. Northern region, 5. Upper East, 1. Something, if you put all this together, it comes to 94 high courts that are sitting in the high country as vacation courts. So wherein lies the issue of abuse of discretion? That to the NPP, and they've singled out only 2 high courts sitting out of this 94 in the entire country. Why? Because they have cases. These lawyers who are also aligned to the NPP have cases before these 2 courts. So everything must be politicized. And the GBA writes to the Chief Justice and claims that the Chief Justice has engaged in selective justice. When the GBA, as a professional association of lawyers, ought to have vetted the issues raised before them by the members before communicating to the Chief Justice. And they threatened the Chief Justice and said all manner of things in their petition to the CJ. Isn't the judiciary supposed to be independent? Can a professional group of lawyers determine how the judiciary should conduct its court and the time? Is it not set in law?
Roxy,
please.
Do they question vacation courts? Do they question that? Do they raise an issue that there shouldn't be vacation courts? Is that the issue? Let me read
GBA's letter to petition, a portion of the petition.
Okay.
It is paragraph. This will be paragraph 1, 2, 3, 4, 5, 6, 7. Innocent parties in a trial, civil or criminal, ought to not be coerced by a judge to represent themselves at the absence of a lawyer, and it's not considered willful during a legal vacation. No step whatsoever ought to be taken in the matter by the judge, apart from adjourning the case to dates proposed by counsel. Is this what the GB is telling the judiciary that is done during vacation?
I ask you a direct question.
I will answer. And I'm saying that the GBA cannot be detecting to the judiciary.
Yeah, that point you have made.
Yes.
Yeah.
So
my question is,
yes,
all these lawyers,
yes,
and the GBA,
yes,
have they questioned vacation courts that they are a rarity or they are unlawful or something like that? Have they said so?
They have said so.
They haven't.
They have.
Where? They haven't said so.
They have.
That there should be vacation courts. Have they said there shouldn't be vacation courts?
They said they cannot, they don't want to appear before a vacation court. In effect, don't have a vacation court.
No, they haven't said so. They said, you just read it. You just read it.
Something.
Yes.
Have you read their petitions?
I've read all of them.
Yes.
So
they are saying.
Let's not misrepresent them.
No, I am not Look, I'm stating the facts.
Okay. Now.
So let's stick to the facts. Yeah. They are saying that, CJ, you have constituted a vacation court.
Good.
And even though you are within the rules, we as the lawyers in matters that are before those vacation courts won't go because we deserve our arrest. One is saying that I have been given money to come and mark exam scripts, so I won't come. Is that a basis to say that you appear in court? Godfrey Dami has about 4 lawyers in his law firm. But who is the managing partner of Samoku Jeto and Associates? They have 31 lawyers. Adjei has 17 lawyers. How do you write to a CJ that you can't appear in a court because you want to take a vacation? As by way of practice, don't we hold briefs for our seniors even if they travel? So this attempt to paint the Chief Justice bad in this matter.
Can I ask questions?
Yes, please. Okay. Please, by all means, proceed.
So vacation courts are normal, correct?
Yes, they are normal.
They have not questioned that vacation courts are normal, correct? You just actually clarified that a while ago.
Yes.
All the problem they have with is that they don't want to be compelled to attend to the vacation courts. Is that correct?
Okay. Now, there's nothing like compulsion. When you take your client's money, that I will defend you at all times, I will offer my legal services to the best of my ability, you are undertaking.
Okay.
in spite of your availability in terms of time and resources, if you can no longer represent the client because you value your legal vacation, you terminate your legal services with the client, you hand over his brief, he goes to look for a lawyer who can handle him.
Fine.
Now, you don't maintain the client and dictate to the court that even though you have 17 lawyers in your law firm, you can't find even one to continue the hearing in your absence.
Now,
that's the point I'm making. What is
the standard for vacation courts in hearing of cases, as you have known it for the 17 years you have practiced? 16. 16 years.
Yes.
Okay.
Now, the point I'm making is this. Sometimes your matter can travel into the vacation. It happens. So, as a lawyer, what you do is that you negotiate with the judge. So, my lord, you know this matter. We've spent some time during term time. And so, I think that in the vacation, even though we are supposed to continue, can we agree and do maybe two or three hearings and then we adjourn it to October? This is how you negotiate.
Okay.
I suspect strongly that if the Honorable Adjei, my senior, if he had appeared, so my lord, with all due respect, you know the vacations, we take it easy. So let's negotiate and do a couple of hearings. And then from September, we move it to October. I don't think my lord would have disagreed.
Okay, so from what you have said, the standard, as you have known it, over your many years of practice, is that...
And I've done serious cases in the vacation.
Okay, that changes the question I'm coming to ask now.
Okay.
Because I just mentioned to Baffuor that I've done 2 emergency cases in the vacation. Why were they called emergency cases? Because they are party primaries. And they were held just before the elections.
Election matter.
Yeah, party primaries. So held just before the election.
Time-bound.
Then EC has issued its deadline for the parties to bring their candidates. So, for example, the first one I did, Kwesi Mintim, the judge finished the case on a Friday, gave the judgment on a Friday. Over the weekend, they did the primaries all over again, picked their candidate. By Monday, they submitted a candidate to EC to avoid, not having a representation. The second one in 2024, Wale Wale, that one too, the EC has a deadline. If the case doesn't get adjudicated quickly, if it doesn't get adjudicated quickly, then it means the MPP will lose the opportunity.
Yes, it was time-bound.
Do you think that those kinds of cases are what you call the real emergency cases that are done during vacations, or other cases?
You can do other cases, regular cases.
Oral cases.
Oral cases.
Are they emergency cases?
Why? Everybody is calling on the government to expeditiously hear the matter. Indeed, me, if I were a lawyer in any of the cases, even the vacation would have been a favorable time for me to expeditiously deal with the trial. Because I'm interested in getting my client off. And so the expeditious hearing shortens the time that I will spend on the matter. So it's a principle that we must all appreciate. Samson, 2011, one of those Ivorian opposition leaders, Adjei, he was living in this country. He was arrested to be extradited. The arrest happened early July. The processes and the court issued spilled over into the vacation. And we had to continue.
Were you compelled to do it, or you really wanted to do it?
I wasn't compelled because I've been paid to offer my legal services. Do you write and say that, it's legal term, so I'm not going to appear?
Have you had a situation where it was vacation, and you appeared before a judge and he said, no, I'm sitting in the vacation whether you like it or not?
Samson, you don't do that as a lawyer.
I'm asking you, have you had that encounter?
No, I've never. By our training at the
bar. This is the encounter they have and they are complaining about.
No, Samson. That wasn't the encounter. They are putting a spin. Look, what Baffuor is alluding that the judge said, I have been warranted to sit in the vacation issued by the CJ. So it's only the CJ that can stop me. What does it mean? It means that it's only the CJ that can revoke the warrant. You are here doing all manner of things. So if the CJ revokes the warrant, then we won't sit. So as a result, you went to petition. And in your petition, you will not even state the facts. You mistake the facts. The entire propaganda is from here. The judge is saying, I have been warranted to sit, to hear cases. And so I want to continue with the cases before me. Regular cases.
Okay,
so if you want me to stop, get the CJ to revoke the warrant. And you are saying that the judge is saying only CJ can stop me, and CJ to say only the judge can stop him. So for me, I think the slant against the Attorney General by what's his name?
Ben Boache.
Ben, it's unfair. I think what the Attorney General, I'm not speaking for him, but I want to surmise that perhaps we're all waiting to get the outcome of the substantive matter before the U.S. court in New York. Now that we have a result, then based on that, he can do some concrete work in terms because it was all allegations, and these matters happened about 12 years ago. So it was
about 11 years ago.
Yes, 2014.
Okay.
Genesis.
Yeah, but properly speaking, 2015.
No, if you trace the history of the transaction.
Right.
So the issues began from about 2014,
That's
15,
correct.
16,
That's right.
17. So I'm tracing it to that fact. So these are over 12 years matter. So I think that now that he has a concrete judgment from the U.S. court on his mind, on his hand, he's giving firm indication, as reported by the DAG, that the AG is already launching to teaming up with the U.S. counterparts to deal with the issue. And I welcome it because we all need it. Look, like Ben Boache said, anybody who took
the first payment of $500,000, $500,000 was on April 15, 2015. Then April
but the first email to kick the transaction happened in 2014.
Right, I get that.
Yes,
I get that.
So
but we need to put on record that our institutions have been assisting the process since 2020. So we know that the Attorney General has been assisting, the OSP has been assisting, and I think recently also IOCO has also suggested.
Yes, I was going to get there. So my point is that the OSP indicated that they have offered tremendous assistance in terms of work investigations from here to back the prosecution of the case in the U.S. So it clearly tells you that prosecutorial institutions have been, or investigative institutions have been involved somehow. And they must have gathered some enough material to be able to launch a full-scale investigation into this matter. Now, the call by the NPP that they don't trust the Attorney General is very interesting.
Before the NPP, Ben is saying that they knew about these things all that way back. So why is it that they too didn't do something like the US?
I was going to get there.
Okay.
You see, when my brother said we the NPP, meanwhile 2017, 2018. So I agree with Ben that yes, the matter has been with us for the past 10 years or more. But the Office of the Attorney General may have decided that let's wait until there's a final determination of the matter before the US. Then we can proceed. I'm just surmising. And that being the case, I think that now they have the opportunity to do so. But the angle that they are pushing, that they don't trust the Attorney General to lead this inquiry is very interesting. Because you speak as a member of parliament. You as a member of parliament, your parliament is indicted. Parliament is indicted. So which institution is going to lead this? You are speaking as a member of parliament. The institution that we all serve has been indicted in this matter. So don't push that angle. Let us all agree that we need to do a further inquiry on our own and to bring out the true facts. And if anybody is guilty, my brother, the law must take its course. Because look, like Ben said, we are struggling to find money to build chief's compound to serve our people. We can't buy life jackets for our people who are traveling on the water lake, and therefore, when the boats run into a storm, we lose lives. Life jackets. So for me, these are the serious matters involved.
something as basic as life jackets.
Thank you very much. We struggle to afford it. So if as a public officer you have a responsibility to do under law, and you corrupted your official duties, you must pay for it. You see, we are not punishing some of these things well enough, and so we all speak about it and we leave it. You must begin to apply the sanction, even if you leave office 10 years ago, and some breaches and improprieties have been found as part of your work when you were in office. You must be called back until we begin to do those things and demand proper accountability. Our future generations will take us serious. They will take us serious. So I'm in favor of the call, and the investigations must be pursued with alacrity. This matter must not drag. We must pursue it with some purpose and speed and dispatch. The report will be prepared, recommendations will come out, we proceed on the recommendations, if any, and then we prosecute, if any, so that this matter can be put to rest.
But do they have a basis, as in, we'll get to them shortly, but do they have a basis by suggesting that the Learned Attorney General has put himself in a situation where he cannot be trusted to prosecute his own? Because we are talking about particularly, say, looking at it from Kwabena Donkor downwards, officials who were in the Mahama administration one. And we're also talking about Mahama's brother. We don't know which of his brothers, we pretend, okay? We don't know which one of them is involved. But of course, people will go back to Airbus matters. Yeah. They'll go back and say, oh, we know this other brother of his who is known to facilitate some of this kind of government procurement and so on and so forth. He's saying that because of the nolle prosequis that were entered, discontinuance that were entered, and a good number of NDC officials who were let go when prosecutions had progressed, it's evidence that he will not.
Now, is he saying that Godfrey Adjei never entered nolle prosequi? I'm here to do the count. But Godfrey Adjei, even as a Deputy Attorney General under Gloria Kufu, he entered nolle prosequi. The basis for entering nolle prosequi in any matter is not for me to decide.
I think it's about high-profile cases, politically exposed persons.
Why? When a group of party people storm a court in the course of court proceedings, can't that matter be a high-profile matter? They entered the nolle prosequi. They said they were not interested. So we can always debate that matter. But I'm saying that the Attorney General, Godfrey Adjei, was in office
I thought they were eventually prosecuted, except that the fines that were slapped on them were too small.
No. The prosecution was in respect of those who went to beat what's his name?
Yes,
security officer.
The liaison officer.
Yes,
correct.
Yes,
but not the judge.
Yeah, okay. But the people who were before court.
Okay.
And they went to attack the court and got them released. Where are they? You became vigilantes. That your colleagues were being prosecuted and therefore they were before court. You stormed the court, and the judge had to run for her dear life. You went to free your colleagues from the strictures of the law and allow them to run. Today they become fugitives of justice. So
I think at the time the report was that those who were needed to assist the prosecution were not, as it were, ready to cooperate.
Wasn't that convenient?
And so it was difficult.
Wasn't that convenient? When about 11 people storm an open court, you say you can't find evidence to even determine the identity. So as for the debate around the why and the why not of entering nolle prosequi, that is up to a debate. But I'm putting it on record that Gloria Kufu entered the nolle prosequi. Godfrey Adjei was her deputy, one of her deputies, I should say. Dami himself got elevated substantive attorney general, he entered nolle prosequi in this nation. So let's leave the matters on nolle prosequi.
You have referred to only one situation, which is actually...
No, which I remember, but I'm saying that if I want to check the records, I can get more. But on top of my head, I remember that one.
In that one, what did you say?
We said it was wrong.
Were you happy about it?
No, I wasn't.
Okay.
I wasn't. So that's what I'm saying. These are debatable matters.
All right.
Now, the Attorney General has suo motu, not without the prompting from anybody. His deputy is saying, my boss has already initiated contact with his counterparts in the US. How more assuring do you want the man to sound? Now, I am saying that the said inquiry should be conducted with alacrity and some dispatch and speed. I think that is what we should all call for. That, okay, if the news is that the AG has initiated processes to deal with the matter, then we want that to be done with some urgency. That's all. I think that's all we should demand and give him some time to deal with the matter. If he's not handling it the way we expect, then we can begin to raise some of these matters. But if ab initio, you yourself, the institution you belong to, you are indicted. You are not coming to this matter with clean hands as a member of parliament. I feel so uncomfortable. And you want parliament to deal with this matter. How is parliament going to deal with this matter when it appears to be in the center of it? Do you understand what I'm saying? Okay. Yeah, so because from the reading of the judgment, it appears that the entire expectation was that parliament should have halted this. But we failed. And that for me is the border. And so be a member of one of the committees that are so important in parliament. It should be slow to making such comments. We should be interested in. So we should even talk about how do we even constitute the team to look into the matter? CSOs, which institutions of state? My issue would be the team to constitute the inquiry and look into it. And not say that the AG cannot be trusted and therefore we should bring the matter to Parliament for Parliament to conduct an inquiry into it. So something.
Right.
I'm calling for, having put all the facts together, I'm calling for a quick look into the matter. If it's prosecutable, we prosecute and then we make progress.
Yeah, thank you. Yeah. And so Roxanne was referring to facts when he spoke about, I just pulled up some of the discussions we had.